Welcome to the New Books Network.
Welcome back to New Books in Political Science, a podcast on the New Books Network. I'm Susan Lee Bell at St. Joseph's University, and today I'm joined by Dr. Kevin J. McMahon to discuss his new book, A Supreme Court Unlike Any Other: The Deepening Divide Between the Justices and the People, published by the University of Chicago Press in 2024. Many scholars and members of the press have argued that John Roberts' Supreme Court is exceptional. While some emphasize the approach to interpreting the Constitution or the justices' conservative ideology, Dr. McMahon suggests that the key issue is democratic legitimacy. Historically, the Supreme Court has always had some democracy gap. Democratically elected presidents appoint justices that serve for life. As presidents select justices, they attempt to move the Supreme Court in their desired ideological direction, while simultaneously advancing their electoral interests and managing their governing coalition. Despite these forces, Dr. McMahon argues that past Supreme Courts were still closer to democratic principles. Today's court is exceptional because the democracy gap is so severe. A Supreme Court, unlike any other, draws on historical and contemporary data to reveal how the long arc of court battles from FDR to Donald Trump created this democracy gap. McMahon highlights changes to the politics of nominating and confirming justices, the changes in who is even considered to be on the court in the pool, and the increased salience of the court in elections. Dr. Kevin J. McMahon is the John R. Reitmeyer Professor of Political Science at Trinity College and the author of 2 award-winning books, Reconsidering Roosevelt on Race and Nixon's Court, both published by the University of Chicago Press. Together with A Supreme Court Unlike Any Other, the 3 books form a trilogy that interrogates whether 100 years of presidential efforts to shape the High Court affect the Supreme Court's democratic legitimacy. Dr. McMahon also writes public-facing essays in outlets such as U.S. News and World Report and The Conversation, and I'll link some of those in the bio. And I'm delighted to welcome him to the New Books Network. Hi, Kevin.
Hi, how are you, Susan? Thank you so much for the invitation.
It's a great book, and as I said to you off audio, I would love color graphs, but other than that, this is an incredibly compelling book, and the graphs are part of what makes it such a terrific contribution to what we know about the Supreme Court. You start this book with the Supreme Court announcing its decision to overturn Roe v. Wade by downloading the opinion on their website. The usual ritual, it's a public ritual, is announcing, it's a big room, it's very impressive. There's often a summary of the decision read, and once in a while there's a dissent, even a summary of the dissent read. But that was not part of this historic moment, even though the decision, Roe v. Wade, had been in place for almost 50 years. 15 justices of various parties had clarified it in almost 50 decisions. So it was a big decision, and yet, as you say, click, and it was out there. Why begin the book with this decision? What does Dobbs tell us about the current state of the U.S. Supreme Court?
I do start the book with the Dobbs decision, and the reason why it was just a click, that's the opening words, right, of the book, is that the pandemic protocols were still in place at the court, so you didn't have the justices reading from the bench as they typically do, both in the majority opinion and if there are concurring opinions, sometimes the justices will read, and certainly I'm sure we would have heard from the dissenters in such a important opinion as Dobbs. So why start with that? Dobbs was really a decision that obviously conservative social conservatives, so-called movement conservatives, had for a long time seen as the most important decision to overturn. So this was certainly an indication that movement conservatism had succeeded. But it was also an opinion that when Americans were asked in public opinion polls if they wanted the court to overturn the opinion or keep it as is. A substantial majority of Americans said that they want to keep it as is. So it's this stark division between what Americans wanted, at least in public opinion polls, and what the court was doing. And this was a court of 6 conservative justices, right? But only 5 of whom joined that majority opinion. Chief Justice Roberts issued a concurring opinion. A dissenting opinion that would have upheld the decision, but not. He didn't want to go so far as overturning Roe. So that's why I begin with the Dobbs opinion.
So the idea of a democracy gap, which is central to the book, can you elaborate? What does it mean sort of qualitatively? And also, is there some sort of quantitative cutoff point at which we know it's a democracy gap as opposed to it's muddier? In this case, not only was public opinion at that moment favoring legalization of most abortion, but it had been so really since the court decided it. So there's all sorts of reasons for picking it, not just the click, but the consistency over time in terms of public opinion. But what is the democracy gap? Where does it come from? Is it your term? Tell us.
I mean, I think it's been used in different forms, but I certainly give my own definition to it. So we often hear about the court as an independent institution, right? That is unelected. The justices serve for life. This gives them a certain amount of authority. They don't have to worry about, the next reelection campaign. So we certainly, as in elementary school or in middle school, we learn of these things that the court sort of sits aside or outside of electoral politics. But if we look at political science literature, particularly Robert Dahl's 1957 essay, which is used a lot and still has a lot of people refer to it, a lot of people cite it, and also Robert McCloskey's book, The American Supreme Court, which is now in like its 7th or 8th edition, updated consistently by Sandy Levinson. What they both say is that looking at history, the court is really part of a dominant political coalition, right? So what our politics have been about historically is these periods of dominant political regimes. So if we think about Thomas Jefferson's Democratic Republican Party, 6 straight elections won at the presidential level in a row. Lincoln's Republicans, again, 6. FDR's Democratic Party, 5 straight elections. So what this allows for is there may be a lag, as Dahl and McCloskey suggest, right? So the best example of that is certainly Franklin Roosevelt. He has a conflict with the court, which leads to his proposed court packing plan. But sooner or later, he gets to, quote unquote, pack the court in the traditional way, right? And what comes, and I say that this is part of the argument in my first book, what comes later is a court that represents that presidential wing of the Democratic Party by Roosevelt, right? So that's sort of how we typically understand, certainly in political science, Supreme Courts, that they are independent, but they are part of this larger coalition, as Robert Jackson, one of the great writers on the Supreme Court, says, sitting at the apex of the federal government, right? They are part of the federal government, even if they are unelected. So where are we today? Well, those dominant coalitions, as we know, are no longer in place. Roosevelt won fairly easily, certainly in 32 and 36, but even in 40 and 44, he won, landslide elections. If we look to the 1970s and 1980s, we had a period where Republicans won 5 of 6 presidential elections in a row. Richard Nixon in 1972 wins a 49-state landslide, more than 60% of the vote. And Ronald Reagan does the same in 1984. He's a little under 60%, but nevertheless a dominant landslide victory. But today we have these series of elections. Democrats have won 7 of the last 8 popular votes. But 6 of the 9 justices, the 6 most conservative justices, are Republican appointees, right? So this is where this connection that once existed between the appointing presidents based on dominant electoral victories and the justices, that gap is growing. So that's essentially what I'm getting at. My argument is that the democracy gap is growing because the electoral connection between the presidency and the Senate and the justices is expanding greatly.
And just to back up on a couple of things, that was great. That was a great summary of all that's going on in this book. Yet if we go back to Roe, where the vote was 7-2, the justices came from Eisenhower appointments, Nixon appointments, 2 appointments, one from Democrat, 2 appointments from Democrats, one from FDR and one from Lyndon Johnson. And the dissenters were also a split. One was appointed by John Kennedy and one was appointed by Nixon. So even if you just go back to 72, which your book is trying to do a way bigger sweep, you see this kind of change from having all of the justices who find the Mississippi legislation to be constitutional, all appointed by Republicans, and all of those who oppose, all being appointed by Democrats. You mentioned one thing about the democracy gap, and I just wanted to ask you about it. This isn't about conservative, right? You can imagine a liberal court that would be illegitimate. And has there been such a court? Has there been a court that ideologically went to the left of where the American population is and therefore could be considered illegitimate?
Yeah, great questions. So certainly, and I guess I'll start with the last part of that question first. You do have occasions, for example, like at the end of the Warren Court, late 60s, early 1970s, where the court sort of becomes part of the political campaign, certainly in 1968, particularly around issues of criminal justice, Nixon's so-called law and order campaign. The court often, we see the court as part of the conversation in the campaign recently, but historically, that doesn't really happen. But in the case of the Warren Court does start issuing a string of opinions. School prayer is a very unpopular decision. The busing decisions are very unpopular. Certainly, some of the law and order cases are very unpopular. You do start to see some of the Warren Court seemingly checking itself a little bit, right? That not issuing decisions as liberal as we might have expected. The Terry case, which deals with search and seizure, is probably the best example of that, where Earl Warren writes this opinion that's supportive of searches, right? And most people at that time probably would expect, given what they had done most recently with like Miranda, they would have expected a different result. So that seems to be checking themselves a little bit. On the first part of that question, my critique is not really a critique about the court's conservatism, right? It is really a critique about the construction of this court, the way it was built, and as I write, if this had been a liberal court constructed in the same fashion, its legitimacy would be equally uncertain.
Okay. No, and I think the book is so clear on that. That's why I asked the question to get it out for everybody, that this isn't a book complaining about the conservatism of the Roberts Court. What it's about is the processes by which the 6, maybe all 9 of the justices got there, and to consider whether this should lead us to ask some further questions about legitimacy, different from what we might have asked in 1980. You describe this and how it happens in this incredible mix. It's a beautiful book in terms of the way it mixes history and graphs and data. So it's qualitative, it's quantitative. But you come up with these ideas, 3 shifts, and I want to just work through them individually. We'll start with the first one, which focuses on choosing and confirming justices. So, first, take us backwards. Like, what did this process of presidents choosing a justice and getting them confirmed by the Senate, what did this look like? And then let's talk about what changed.
Yeah, so I sort of break up the book, or that portion of the book, into these different periods that we tend to know as political scientists, or periods of one party dominance, right? From the founding to the Civil War period, New Deal period, divided government, right? So what we tended to see, certainly in the 20th century, is that presidents did not have much difficulty in naming the types of justices that they wanted, even really naming the individuals. You certainly, in the 19th century, there's more complications. Andrew Jackson certainly has a harder time getting his justices on the court than we might expect, given his dominance at the ballot box. And I sort of go through this, what I call, borrowing from Mayhew, and an electoral connection between presidential victory and success in the Senate with regard to Supreme Court confirmation. So we do see some differences, but what you tend to see is that dominant presidents, electorally dominant presidents, so I define that as somebody who wins more than 50% of the vote, and has a victory of more than 5%, that they tend to have a much greater success than somebody who has a narrower victory, right? And that's even great, even harder time is those presidents who are never elected, who get into office due to the death of the sitting president. So this is what we should expect, right? The dominant presidents, those who do well at the ballot box, should be able to command or have a great power in influencing what the court looks like. Again, this gets to this idea of a democracy gap. So the justices are not elected, but we know that the presidents that we elect have a strong hand in determining who sits on the court. The other thing that I argue is that when the Senate voices opposition to nominees, and I say that this is for justices who attract more than 25% of the vote in the Senate, that typically these individuals don't become justices, right? That the Senate's voice is historically is quite powerful. If the Senate objects in a substantial way, those justices typically don't become those nominees typically don't become justices. Today, obviously, that's changed, right? We know that if you have a president and the majority in the Senate is of the same party, the filibuster is gone, right? And all you need to do is you need to get 50 votes, and you're going to get your nominee through. Now, what a quick example of this, I already mentioned the Nixon election and the Reagan election. These great victories, not too far in the distant future, produced nominees that were often not the ideologues that the presidents wanted, right? That they had to consistently compromise on the types of nominees that they selected. And this results in part of the frustration on the part of conservatives, right? In 1992, when the court announces the Casey decision, probably the most important abortion decision after Roe's from 73, 10 justices, the last 10 justices had been Republican appointees. The only Democratic appointee who was on the court at that time was Justice White, who was a dissenter in Roe, right? So the expectation there is that the court's going to overturn Roe in 92. It doesn't, right? It reaffirms Roe. It certainly it restricts the right to choose in a variety of ways, but it doesn't overturn it, right? That's because the Senate was checking the power of the presidents to appoint. That's the best, clearest indication that the Senate is effective in limiting the conservative ideology of the justices who are appointed. Today, what do we have? We have
Here, wait, before we go to
sorry,
today, let me
sure,
ask you a little bit about the past.
sure,
No,
sure,
this is
yeah,
great. No, I mean, I know what you're summarizing because this is such a complicated book. So this is amazing. Um, so it's so compelling and it makes so much sense, especially when, you know the names, which not everybody needs to for reading this book. This is not a court insider book. And this can be assigned to students. This can be assigned to graduate students. This can be used in research. It's very, very accessibly written. And it doesn't have this wink, wink, nod thing about like, you should know, who appointed Justice Powell. It's not like that. So well done on that regard. So but once you do see who's appointed and what happens to them, many of the Nixon appointees, Eisenhower appointees, are not what those presidents were hoping they would be. They move over the course of their careers sometimes to become some of the most liberal justices. Justice Brennan is a good example of that. And you do a great job of showing how all of this happens. I think one question, and I asked this based on your first, on the first book in this trilogy, is what would you say to the fact that FDR's incredible dominance of the presidential elections was based on a coalition that came out of segregation? I mean, he was able to win the numbers of states that he did, the electoral college that he did, in part because of not passing things like lynching legislation, of keeping that wing of the Democratic Party that wanted to preserve Jim Crow and segregation. So what would you say to that in terms of how we negotiate the democratic legitimacy of big wins from a president?
yeah. So it's again an excellent question. I mean that's really a focus of the first book, Reconsidering Roosevelt on Race. The subtitle of that book is How the Presidency Paved the Way to Brown. Right. So what I argue there is that a lot of scholars have looked at particularly with regard to Congress. Katz Nelson is certainly one of them, where the New Deal wasn't very progressive on race, and that's certainly true, right? That there's many pieces of civil rights legislation that are proposed in Congress during Roosevelt's term, and none of them pass, including anti-lynching legislation, which is sort of the most basic of rights. But what the Roosevelt Justice Department does do, what Roosevelt does do, he does two things. One, he initiates under the leadership of Attorney General Frank Murphy, who later becomes a justice. And then of Robert Jackson, who also later becomes a justice. These are two attorney generals who then become justices. They start essentially a civil rights campaign within the Justice Department, dealing with criminal law. They're trying to take these old Reconstruction laws and try to give them some life. This is obviously at the same time the NAACP is carrying out its segregation campaign, right? So a lot of times the Justice Department is working with the NAACP, and then with regard to the appointees, Roosevelt ultimately is able to appoint 9 justices to the court. One, Jimmy Burns, only serves for a year because of the war, but many of these justices, Hugo Black, William Douglas, Frank Murphy, doesn't live a long life, but they become leading liberals on the court. When the court decides Brown, 5 of those, and unanimously, 5 of those justices are Roosevelt appointees. Black is the first to really aggressively argue, that it's time. This is a former Alabama senator who was once a member of the KKK, right? Argues that the court has to overturn Plessy, right? So that's essentially the connection I make between Roosevelt and the court's product in Brown.
I guess I'm not going to push this too hard, but so this idea of the people is always one that bugs me. It bugs me when Madison uses it, because he doesn't mean the people. He doesn't mean any of the people with with ovaries. He doesn't mean certain people who are enslaved. He doesn't actually mean the people, but the people functions as this slippery concept. And I think it continues actually now of this question of like, well, do the justices represent the people? And so in the FDR landslides, I guess the only thing I would push back, I love that story, and I loved that. I loved your first book and learned just a great deal from it, and how it is that those people in the Justice Department actually end up on the court writing the Korematsu decision dissents and pushing back in these interesting ways. So it's all fascinating, and I'm not discounting that at all, that Roosevelt does do something. But in terms of how many votes he got, like, I'm not really clear that he has democratic legitimacy because of the inability of most Black Americans below the Mason-Dixon line, to have voted. And I'm, again, don't want to push it, but I do think it's a really interesting question about what it is counts as a Democratic majority.
Sure. No, that's a fair comment. I mean, I think if Roosevelt were sitting here, right, if we could revive Roosevelt, what he would say is that because of the system that you're talking about, that excludes the vast majority of African Americans living below the Mason-Dixon line, that he's not going to be able to pass civil rights legislation. So what's the point in coming out and supporting it, right? So this is sort of what I say is it's a politics by other means that he pursues. One quick example. The poll tax. The poll tax frustrates him a great deal because he feels that the people that he can get the most votes from, poor whites and poor Blacks, are excluded from voting because they can't afford to pay for this poll tax, right? So what it does, it shrinks the pool of voters to more of a much more upper class, middle class type of voter, certainly white. So he wants to expand the voting pool, and part of the reason that he's pursuing this campaign in the Justice Department through the courts is to do that, to undermine Southern white supremacy.
So let's go to what changed. So we have the sort of general patterns and the importance of the filibuster, these two institutions that are elected statewide, which is very interesting because that means gerrymandering is less of an issue in the Senate than it would be in the House. So what do we have now, and what is this shift to what you call these numerical minority justices, which I love this term.
Yeah, so this is really it even surprised me. I mean, I knew that obviously votes like Clarence Thomas's vote was very close. Brett Kavanaugh's vote was very close in terms of how many senators opposed and how many senators supported. But what I did was I went and I essentially counted every vote that the supporting senators collected in their most recent election and those that opposed. In the case of Kavanaugh, 24.5 million more Americans voted for those in opposition to his nomination than those in support, right? So there are now 5 numerical minority justices on the court. They are the 5 most conservative justices on the court, and they are the 5 that joined together to strike down Roe and Dobbs, right? So to me, this represents and I think they are the only 5 in American history, right? Which starts after the 17th Amendment changes the nature of the Senate from one appointed by state legislatures to one elected by the people of the individual states.
If that were the only thing that you said in the book, that would still be worth reading the book, because that, and again, a lot of the charts are like this. This is why I say to people, like, the podcast isn't going to be enough. You kind of need to buy the book so that you can look at the charts. Just those kinds of mic drop moments in the book, all done through the data, are really what I think makes this book very, very special. And this I really, really appreciate it, and it's something that's useful for me in my own research. I can't do that kind of counting, and I wouldn't. I've made the claim that this is minority rule, but without the kind of evidence that you give me for my next
Right.
claim.
Well, I just listened to the audiobook, and it makes it particularly difficult because, as you're suggesting, the tables and charts and figures play a big role. So
Okay, you could listen to it in the car, and then when you get to the office, you could take a look
that's right.
at the. Okay, so we have this first shift, and that is really about what kind of power presidents have and how it is that they choose and confirm. And one of the things you say is that you can't just look at whether a president gets his pick. It's that the president is strategically picking people that he knows will clear the Senate. And I actually
Correct.
shouldn't say people, because really in this period, we're only talking about men
That's right.
picking
Yeah,
men. Uh,
that's right.
but there's a second shift, and that has to do with the who. Of like who it is that is part of this pool. So tell us a little bit about what happens and where we are right now with this very unique group of people.
Yeah, I mean, just to bring up some of the individuals that I've spoken about already, right? The types of individuals who would become justices, and this is basically for much of the 20th century, up until around 1970. You had individuals who were politically connected, right? So for example, I mentioned Hugo Black, a sitting senator from the state of Alabama, Earl Warren, former governor of the state of California, former vice presidential nominee for the Republican Party, right? So these were people, I talk about this dominant political coalition. These were people who were allies of the president, either in the administration or in Congress, right? So the president knew them well. Sometimes he even played poker with them, as I mentioned in the book, right? In the case of FDR, and they had diverse backgrounds. They ran for elective office. In the case of Hugo Black, went to University of Alabama. There was geography in terms of diversity, religious diversity, lots of diversity. Not diversity with regard to gender and race, certainly, but in these other areas there was a lot of diversity. Today, we basically have. I used to be able to tell my students, if you want to be Supreme Court justices, you could go to any law school you wanted to, as long as it was Harvard or Yale, right? So Amy Coney Barrett obviously changed that. She went to Notre Dame, but we have a justices, I call it the supreme elite, and this is both on the Republican side and the Democratic side, that basically get their card punched very early in life. As I write, when a thick envelope arrives, I'm not sure if this still happens today, but certainly in my day, when a thick envelope arrives from New Haven or Cambridge, Massachusetts, right, that they go to Ivy League law, they go to Ivy League undergraduates institutions, then they go to either Harvard or Yale, right? And it even extends further than that. There are 37,000 high schools in the United States. 2 of the 9 justices went to the same high school, Georgetown Prep, this elite prep school that sits on the outskirts of Washington, D.C., right? So the argument is that we have a cookie cutter court because the justices live a very similar life, right? They go to this elite undergraduate, they go to elite high school typically, elite undergraduate institution, elite law school. Many of them then go and clerk at the court. They then work in the Justice Department, and then they get appointed to a court of appeals, usually before they're 40 years old. Then if they show themselves to be on the conservative side, to be properly conservative, because they are connected to the Federal Society, they are tapped on the shoulder as part of the supreme elite, and they get to be part of the court. This eliminates a whole array of of pre-court experiences that were once on the court that no longer are. Now, the best example of this, perhaps, the last justice to go to a public institution for undergraduate was appointed in 1969, the last to attend a public institution for law school appointed in 1957. So as our nation becomes more diverse in terms of the court, it becomes much less diverse. And you could achieve the types of racial and gender diversity that the court is now this court now has that it didn't have previously. You could achieve this and perhaps achieve it to a greater extent if you expanded the pool of justices, of nominees who could be picked.
Well, you'd be adding a different kind of class diversity and also, as you say, experience diversity. When all of your justices come from the coasts, when a majority of them have grown up in very particular cities that are rarefied. New York, DC, these are Boston, these are not places that resemble the rest of the United States. That's part of their charm, and it's part of the rest of the nation's charm. And it's fascinating when you think about, and I often tell this to my students, that Sandra Day O'Connor is like the last justice who actually was elected to something. And she often, in her opinions or in oral arguments, would say, "Oh, that don't talk about the legislature that way." Like, she understood legislative intent because she'd been part of an Arizona state legislature, whereas everyone else was looking at it in this very theoretical way because, as you said, by the time they're 40, they're already in this lane, and the off-ramp is to go on to the Supreme Court. In fact, you talked about the clerks. The clerks can't even go to other schools other than those elite. So they're not even hearing ideas from their clerks that might represent other places, public school experiences, as opposed to private school experiences. Okay, you have a third shift that you want us to attend to. So, okay, so we have the president appointing, we have the who they're appointing, but you also say that there's something else going on in our elections that you think actually is very, very important in terms of thinking about democratic legitimacy. You want to expand on that a
Sure.
little bit?
Yeah. So the first two basically make the case that the court is less legitimate from a democratic standpoint, right? The first two shifts. But then I explore the possibility that, given the fact that the court, which as I said earlier, typically is not part of the presidential campaign, has been recently, right? So 2016 with the death of Justice Scalia, 2018, these are obviously Senate elections with the recent confirmation of Brett Kavanaugh. 2020 with the death of Ruth Bader Ginsburg in September, right before the election, as people were actually voting already through mail-in ballots. And then in 2022 with the recent overturning of Roe and Dobbs, that the court has very much been part of the conversation of the campaign. So the question is, well, if you have voters knowing that Donald Trump is going to fill the seats with a certain type of nominee, and if, in the case of 2016, Hillary Clinton, or 20, Joe Biden, is going to fill the court with a certain type of nominee, does this add some type of democratic legitimacy with regard to the individuals who who wins the election, and then who they appoint, right? So I say there's something to that, but when you dig deep into both the presidential election and how important this issue was to voters, it was certainly very important in 2016, not so important in 2020. That there's something there, but it doesn't diminish the gap to a significant degree to make the court more legitimate than previous courts.
Voters would have to be one issue voters, and their issue would have to be the Supreme Court. And so I found that part of the book really interesting, this idea that, well, if there was a focus on it, if as president or as a governor for state Supreme Courts, I know your book is not about that, but it made me think quite a bit about some recent elections in which it was the issue. For example, maybe Wisconsin, that you could say, appoint me, and this is what will happen. I don't think in 2024, we're recording this in the end of August in 2024. I don't know that Harris is articulating that as like a number one idea that, listen, if Donald Trump is elected again, both Clarence Thomas and Sam Alito will resign from the court and they'll be replaced with 40-year-old versions of themselves. And so this process will continue even longer than you might think. Those are both justices that are older. So, and they tend to resign when they think they'll be replaced by somebody like themselves. Now, you end the book on a very sort of reform-minded, optimistic note, and I'll say that overall, I think the book is very good about its tone. It's non-ideological in a lot of ways. What it's trying to do is say, like, this is where we are, and it ends by saying, well, like, what could we do about it? And you say that there are some possible reforms to the Supreme Court that have been discussed. One about making the number of justices bigger, and the other limiting the time. And we just heard recently Joe Biden put forth a little bit of this. And then you have a third way, which is a very democratic way of approaching this. So what is the possibility of these reform movements? How realistic do you think they might be, and would you welcome them?
Yeah, I mean, just to go through the packing idea, expanding the court by some number. Some people say when the Republicans blocked President Barack Obama's nomination of Merrick Garland, that this is sort of a seat that was stolen by the Republican majority in the Senate. So therefore, you sort of try to collect a number of seats and expand it by that number. I find that particularly problematic because I think they'll ultimately will be sort of a one-upmanship. The Democrats add 2, Republicans come in, they add 2, or something like that. Part of the reason why this was proposed back in the 30s by Roosevelt is because he understood the difficulty, and I talk a lot. I have a chapter on part of a chapter on this in the book about how difficult it is to amend the Constitution, right? Because of the difficulty in amending the Constitution, court packing was most enticing to him. Obviously, it failed. And it's sort of an easy way to do it because you can do it legislatively, right? You don't need a constitutional amendment. But again, I find that one particularly problematic. The 18-year idea, which President Biden has recently supported, and you may hear a little bit about this, in the fall of the campaign. I think it's an excellent idea, right? The idea that you keep it at 9 justices every 2 years, Justice so-and-so will be departing. When people go to the polls, they will know if I support Trump or Harris, I know that these are the 2 justices who are going to leave, and these are the types of nominees that are going to replace those justices. So from a democratic gap standpoint, I think that's a great idea. Whether it could pass in the Congress is obviously a question. And of course, we don't know how the court would deal with this question, right? I mean, there would be some objection, some appeal that this is an unconstitutional piece of legislation, and who would decide that but the justices themselves, right? So talk about the conflict of interest. There's quite a conflict there.
And it's also interesting. That approach requires us to admit that the Supreme Court is a political institution just like the Congress and the president. And that seems to be something that only recently do the American people seem ready for. The public opinion numbers for the justices have plummeted. The belief that the Supreme Court is political has increased. So I think that it's good that you started the book with Dobbs. Dobbs, and it could have been another case, but this was the one that people focused on, really did make people understand, oh, it's just political. Like they're making this up. Like they have to be making it up because all of these other justices said this for all of these years, but now the Constitution, which hasn't changed, means something else. And I think that was a kind of the emperor has no clothes moment. But the length of time thing really does make the justices would have to say we're political. And so far, only Sotomayor has really said that in print and just said, that's what you're
Yeah,
doing. It's what she said in the Dobbs dissent.
that's right.
Really.
Yeah. I mean, one thing I point out in the book is just how long the justices are serving today than they once did, right? And I point to Clarence Thomas, who soon after he was confirmed said, he was 43 years old, very young for a justice. He said, I intend to serve for 43 years because liberals made my life miserable for 43 years, and I intend to make their lives miserable for 43 years. So if we take him at his word and he's able to do this, that would mean, again, this is sort of another democracy gap problem. And he's the oldest justice. I believe he's 75 now, right? We know that justices served well into their 80s. Ruth Bader Ginsburg was 87 years old when she died. John Paul Stevens was 90 when he retired. So let's just say, for the sake of argument, that he's able to fulfill that. That would mean that we would not, and he retires in 2034, it would mean that we wouldn't have a changed court in 12 years. That would be unprecedented. And it might mean that Kamala Harris would get elected in the fall, reelected in 2028, and not have an opportunity to alter the court. That would be, we've only had one president to serve, an elected president to serve a full term. That was Jimmy Carter, without an appointment to the court. FDR didn't get one in his first term, but he did. He got a bunch in the second and third. That also gets at the heart of this idea of a democracy gap, right? You have a president elected twice, not able to change the court.
And the only way she would be able to make a change would be for Sotomayor to retire and for Sotomayor to be replaced with a 40-year-old. So that would extend the liberal presence on the court. But again, that requires for somebody to step down. Ruth Bader Ginsburg didn't make such a choice, and she's been criticized for it. Okay, you also have a third possibility, which hasn't been mentioned, which is that there would be a backlash, that in fact Dobbs angered people and made it clear that the court is simply political. If you put people on who oppose abortion, all of a sudden the Constitution will oppose abortion. That's simple and easy for people to see. So tell us a little bit about how that progressive backlash might function and how democratic would that be? Would that be the most democratic way?
Right. So that's this is essentially taking, learning a lesson from Republicans of the last 50 years, who learned a lesson from Democrats of the period before that when you lose in court, it doesn't mean you lose politically, right? That the Democrats have certainly highlighted the Dobbs decision as a way to perform surprisingly well in 2022 in the fall elections. The red tide became a red ripple, right? The abortion issue will be an issue for this fall campaign, right? So the idea is not, I suggest that too long liberals went to the courts and tried to convince judges and justices that this was the right decision to make, right? And they succeeded in that. And what democracy ultimately requires is you to do the hard work, right? Knocking on doors, the grassroots effort, that the nature of the Senate sort of requires a party to be national, not just be winning in Brooklyn and Los Angeles, right? That you need to win everywhere. That's just the nature of the structure of our system. And to control the court, you need to win in places like, Montana and North Dakota and all these places. That's how you would that's the third option, right? Not doing anything to alter the court, winning politically.
Right, and there's one of my favorite graphics the New York Times ever did is it shows, I think it's 10 senators, and then it shows behind them, like 30 senators. I'm getting the numbers wrong here, but I'll put the link in the show note. And they represent the same number of people, right? Because the Senate isn't the democratic institution. It's about whether you win a state. And that poses a challenge as people have migrated so that they live more and more separately. So it's a big challenge, but it is interesting, and I think we'll see based on what happens this year with more and more referenda on the ballot as to whether or not that brings people out in these states. And we've seen already that states like Kansas and Kentucky and Ohio that people thought were clearly red and would clearly turn down abortion being legal, instead put it into their constitutions permanently, making it even harder for politically appointed justices or elected justices in some states to make these changes. I have like this fantasy, this democratic fantasy that will never happen, which I wanted to put pressure on Neil Gorsuch to step down, to just say, like, that the president of the United States appointed Merrick Garland, and that the Republican president of the Senate just refused to hold a vote. So you should step down, because that you shouldn't be there. And similarly for Amy Coney Barrett, that that this was pushed through and you should step down. Now there's no way to like collect those signatures, but that's like my little democratic fantasy, is that somehow you could shame people through kind of collective cultural delegitimizing of why they're on the court, because I don't think either one of them really, it's bizarre to me that I guess you accept it because it's a life appointment, but
yeah, it's what they've strived to achieve their whole life, right?
okay, you spent a long time writing this book, and as you explain in the acknowledgments, like you weren't really planning to write 3 books on this, but it happened. Is there something that we have not talked about that was really important to you in the writing of this book, and we should end with that?
Let's see. Well, I guess the final thing would be just to pick up where you were leaving off, right? Where liberals or progressives will go from now. I mean, we've talked about the idea of the politics of it all. And just to highlight an aspect that I mentioned a little bit, but not too much, is that the constitutional amendment route is really closed off, particularly for progressives. The way it's structured, it's still difficult for conservatives, but it's possible to achieve a constitutional amendment for conservatives. For progressives, it's virtually impossible. So, yeah, it's I've spent a lot of time writing these 3 books together, I guess, and it's good that the 3rd one is now done.
Well, I really, really appreciate you coming to talk about it, and also being willing to dive into the other 2 when necessary. I learned so much from this book. I will be pointing students to the charts, and some of the anecdotes will just make their way into what I'm teaching. So thank you
That's
so
great
much,
to
because
hear.
it takes a lot of years to put this kind of thing together. Uh,
Well, thank you so much for the invitation. I really appreciated the conversation.
Oh, and shout out to Mary Dudas for suggesting the book. And, I always say to people, just write me. Let me know if there's a book that we haven't done, or a book you've written that we haven't done. Don't be shy. So I've been talking to Kevin J. McMahon about his new book, A Supreme Court Unlike Any Other: The Deepening Divide Between the Justices and the People, published by the University of Chicago Press, 2024. Thanks so much, Kevin.
Thank you.